To bring in my first guest today, Federal Families and Social Services Minister Paul Fletcher joins me. He's, of course, responsible for the Redress Scheme. Minister, welcome.
Good to be with you, Patricia.
In a major backflip, the Catholic Church announced its entities will enter the National Redress Scheme individually and not as a single church entity as they originally planned. Now, survivors and their lawyers fear lengthy delays in getting redress payments from the church because of this. Do you share their concerns?
Well, it is important that we get as many institutions joining the National Redress Scheme as possible. As you know, under the scheme, a survivor can receive counselling, they can receive a redress payment, and they can receive an apology from the institution, a personalised apology should they wish that. So our focus over the past several months has been on getting as many institutions as possible to join the scheme so that when people make applications, their application can be processed, because an institution needs to have joined the scheme for that to occur. Just today, for example, I've announced another 7 institutions, including the Christian Brothers and the Morris Brothers, have joined the National Redress Scheme, and that builds on many Catholic dioceses around the country, a number of Anglican dioceses, all state and territory governments, which of course ran many institutions, and quite a number of other organisations as well.
So, Minister, given the Catholic Church is really in the spotlight right now, what's your message to those who have yet to sign up? Because your predecessor, the Attorney General Christian Porter, told me that he was very disappointed some time ago. Are you disappointed at those that have still held off?
My message is that institutions where historical child sexual abuse may have occurred should join the scheme. I urge them, and the Australian Government expects them, to focus on this as a matter of priority, because the scheme is designed to deliver recognition to and acknowledgement to Australians who suffered terrible abuse. Of course, no compensation payment can ever make up for what was taken away from an innocent child, but it is important that people have the right to their redress payment, to counselling and to a tailored apology. And so I call on any institution where historical child sexual abuse may have occurred to join the scheme.
Are you prepared to name and shame?
I announced, together with the state and territory ministers in December, that early this year we would commence listing institutions which have joined and institutions which have not joined, and we'll be doing that quite shortly.
Okay, when you say quite shortly, when? And will that involve you as the minister getting on the front foot? And as I say, shaming, I mean, I'm being pretty blunt with my question, shaming them nationally for not participating.
We will be very clear as to which institutions named in the Royal Commission have joined and which have not joined, because this is very important. Right now we have a little over 2,700 applications that have been received. Of those, around 900, we can't yet determine which institution the abuse occurred in. There's more work that needs to be done between my department and the applicant to nail down the facts.
Okay.
In respect, but just let me finish this point. In respect of those where we do know the institution, now slightly over 50%, around 52% of the applications for redress concern an institution which has joined the scheme, but we need to see all of the institutions where abuse may have occurred join the scheme. That will continue to be a very strong priority for this government. We will continue to press institutions to join, and when we do publish the list of those that have joined and those that have not joined, that will be important so survivors are aware of which institutions have joined. One of the reasons that's important is because we tend to see a spike in applications from survivors once they know that the institution where they suffered abuse has joined.
Has there been a spike since the George Pell case has been running over the last couple of days?
Not that we have seen just in the last day or two, but I do expect that this will heighten awareness amongst survivors, and I do expect that we will see significant additional numbers of applications coming forward, and that is what the National Redress Scheme is there for. It is to provide redress, and we need, therefore, survivors to come forward should they be minded to do so. Let's bear in mind this is a very, very difficult process for any survivor, and it requires them to work through very painful exposure that they had, in many cases 20, 30, 40, 50 or more years ago, and the processes we've got in place are designed to be sensitive to that, and it's entirely a matter for survivors as to whether they want to take up the National Redress Scheme, but it's very important that it is there for those who choose to take it up.
Minister, George Pell spearheaded the Melbourne response, which capped payouts for victims of abuse. There are now calls for that scheme to be scrapped. Should it be?
My focus is on the scheme that the Australian government, together with state and territory governments, and of course with the underlying institutions, is charged with delivering. We have got a significant workload there with a view to delivering to survivors the appropriate apology, counselling and a redress payment, and that is keeping us very fully engaged.
Okay, well, Minister, why not increase the maximum compensation payment to $200,000, which the Royal Commission actually recommended?
The compensation payment was agreed on between the Commonwealth and state and territory governments. So we took the recommendations of the Royal Commission, made some changes. The average payment we expect under the final model that was agreed on will be a little larger than the average payment that would have occurred under the model the Royal Commission recommended. Fundamentally, we've accepted the Royal Commission's recommendations, but we've made some design changes. Those were made quite some months ago, and we're now in the process of implementing the scheme, including those compensations.
So you're not willing to revisit that, given there has been a strong critique, actually over the last couple of days specifically in the wake of this Cardinal Pell news, about that cap?
The issue as to the size of compensation payments, the cap of $150,000, was worked through pretty comprehensively.
So you won't revisit it? I know you say you've worked through it comprehensively, but there are calls now for it to be reviewed. Are you ruling that out?
What I'm saying is that we've worked through a careful process between the Commonwealth and state and territory governments. That was done quite some months ago, weighing up all of the competing issues, and that was the figure that was arrived at in consultation between the Commonwealth and state and territory governments, and that's the scheme which, as Minister, I'm charged with administering, working with the state and territory ministers, and our focus is on getting as many institutions as possible into the scheme and getting as many applications as survivors wish to bring dealt with in a timely fashion, but also in a caring and a sensitive fashion. Yesterday
you said the news that someone of George Pell's seniority within the Catholic Church has been convicted is deeply disturbing. That's how you described it. Today we found out that former Prime Minister John Howard has provided a character reference to Cardinal Pell. Is that appropriate?
Our system of justice has a number of features, including people who are facing sentencing, having the opportunity to obtain and provide character references. That's as it should be, and then the court will make its judgment. I'm not going to in any way second guess or comment upon what the court decides, but that is
Sure, but do you think it's appropriate? Would you have provided a character reference?
I am not going to second guess decisions that others may have made. I simply make the point that it is a well-accepted feature of our system of justice that when somebody is about to be sentenced, they have the right to provide character references, and that's a matter that a court can choose to take into account, but it's a decision for the court.
So it doesn't concern you at all?
This is a part of the process which occurs as part of our justice system.
What message does it send to survivors?
It is a matter for the court to decide what weight it attaches to character references, but this has been a feature of our justice system for a very long time because a court needs to weigh up a whole range of factors, including questions as to the character
OK. Are you still appalled? I'm just wondering, I mean, there was the conviction yesterday. He's right now behind bars. What are your feelings about this? This is quite a significant and historical day in Australia.
Of course it is, and as the Prime Minister has said, as I have said, as other political figures of all political persuasions and other community leaders have said, you know, this is shocking and troubling. As the Prime Minister has pointed out, what it shows is that our justice system operates without fear or favour, and nobody is above the law. That's as it should be. We've had a process where a court and a jury has considered the evidence and brought down a verdict. Of course, there's now the right of appeal, which would be available to anybody in this situation. This is our justice system working. I'm not going to comment on the merits of the decision. That is a matter for the courts, quite properly.
Just another question, another topic, which we're going to discuss in this hour, and that's this Royal Commission into abuse in the disability sector. Prime Minister's now written this letter to states and territories to try and get them on board. What kind of time frame are we talking about for this Royal Commission? Could it happen before the election? Well,
what is important is that we do have the states and territories indicating their willingness to participate. A Royal Commission looking at abuse and violence against people with disability necessarily is going to have much of its focus on institutions operated by state governments and a system, the disability system, which until very recently was almost exclusively a matter of state responsibility.
So could it happen before the election?
Well, we need to work through what the responses of the states and territories are.
Would you like to see it happen before the election? I'm just trying to get an indication on time frame.
Well, we'll work through it in a timely fashion based upon the responses we get from the states and territories. It is important that
Would
we
it
have
be
the states
your
and
wish, Minister, I'm going to go there one more time, would it be your wish to see this up and running before the federal election?
What I want to see, what the government wants to see, is that we get the states and territories involved, that we develop terms of reference which are well-based, which involve appropriate consultation with Australians with disability, and we have a clear understanding of the resourcing. You know, Mr Shorten said this could be done for $26 million. The Royal Commission institutional child sex abuse cost over $400 million. So we're going about this in a methodical, proper, responsible fashion to identify what's needed for this Royal Commission to be effective. That's the work we're doing. That's the work that governments do.
Minister, thanks so much for your time.